The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters, as well as some employment law issues and family law issues. I practice here in the state of Iowa. Now, today we're going to talk about Iowa's implied consent law. If you are pulled over in Iowa and an officer demands a blood alcohol test, can you refuse? Now, under Iowa's implied consent law, any person who operates a motor vehicle is deemed to have given consent to a chemical test for breath, blood, and or urine if there are reasonable grounds to believe the person was operating the vehicle while intoxicated. When will a chemical test be required? Officers are authorized to request a chemical test if there are reasonable grounds to believe the person is operating their vehicle while intoxicated, and one of the following. The person is lawfully under arrest for an OWI. The person was involved in a motor vehicle accident involving bodily injury or death. The person refused to take a preliminary screening test, also known as a PBT. The PBT showed the blood alcohol content at 0.08 or more. The PBT indicated a BAC of less than 0.08, and the officer had reasonable grounds to believe the person is under influence of drugs or a combination of drugs and alcohol. A PBT indicated a BAC of 0.04 or more, and the person was operating a commercial motor vehicle. And finally, if the PBT indicated a BAC of at least 0.02 and the person is under 21. Once a driver is arrested for an OWI, the officer will generally decide what type of test to administer, whether it be blood, urine, or breath. A driver who agrees to take a breath or urine test can typically refuse to take a blood test without penalty. The test must be requested within 2 hours after the PBT is administered, refused, or the arrest is made, whichever occurs first. If the officer fails to request a chemical test within that time frame, the driver isn't required to submit a test. Now, what happens if you refuse a test? Consequences of refusing to take a chemical test are license revocation, civil penalty, and ineligibility for a deferred judgment. The officer must advise drivers of the consequences of failing or refusing to take a test. Finally, evidence of refusal to take a test can be admissible in court to show that you were under the influence. Now let's talk about administrative suspension for refusal to test. The Iowa DMV will suspend somebody's driving privileges for 1 year for refusing to take a chemical test. If the person has a prior OWI, the suspension will extend to 2 years. If your driving privileges are revoked, you will also be fined $200. Once a driver refuses to take a chemical test, the arresting officer can immediately take the person's license, issuing them a temporary 10-day license. If this happens to you, you can contest the revocation at an administrative hearing. The offender can apply for a temporary restricted license, but will have to pay $200 in fines and install an ignition interlock device to their vehicle if they choose to do so. Can refusal be used against somebody in a criminal case? The answer is yes. A consequence of refusing a chemical test is that the prosecutor can present evidence of the refusal in your criminal case and can suggest to the judge and jury that this refusal is evidence of guilt. To put it another way, the prosecutor can argue that you refused to take the test because you knew you would fail. What is the eligibility for a deferred adjudication? Deferred adjudication allows first-time OWI offenders to avoid mandatory penalties such as large fines and jail time. However, chemical test refusal will bar you from deferred adjudication in an OWI case. To conclude, while a driver may refuse to submit for chemical testing, the penalties for refusing to do so in Iowa are often many times more severe than failing a test. In Iowa, license revocation for refusal can be up to 2 times longer than getting a DUI or a OWI. Finally, there are some circumstances that allow police to administer testing without the driver's consent. If an OWI arrest results in an accident causing death or injury likely to cause death, a chemical test can be administered without the consent of the driver. As always, if you have any additional questions, feel free to reach out. Thank you very much, and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.